Welcome everybody to the AWM Capital Name, Image, and Likeness, also known as NIL mini podcast series. I'm your host, Will McGuffey, and I'm an attorney, private wealth advisor, and certified financial planner at AWM Capital. The goal of this series really is just to inform our listeners about what NIL is and what they should be thinking about as they navigate the NIL landscape. We plan to have several guests during this series that will each give a unique perspective into what NIL is and give our audience a game plan on how to handle their situation and the things that they should be thinking about. Our first guest today is David Fleshman. Welcome to the show, David.
Thanks, Will. Glad to be here.
No, I'm excited for this. To give you all a little background on David, David's a partner here in Baton Rouge at Breazeale, Sachse, and Wilson. He and I also had the privilege of teaching the sports law class together this past fall at LSU Law School. Quite an adventure. He was also a member of LSU's last Final Four basketball team, although I'm sure we all want that to change this year. We've got a chance. But most importantly, he's a specialist in the NIL landscape. Over the years, he and I have had the opportunity to work together on a number of projects in the sports law space as well. With all that being said, though, I think probably the most remarkable part about David's resume is that we were the same 1L section of law school. He was a wide receiver on a notorious flag football team that I had the opportunity to quarterback. We studied for the bar exam together. There's a lot of stories. There's a lot of history. But the fact that he still claims me as a friend today is probably the biggest part of your resume I'd like to compliment. So with all that being said, Dave, can you just give us an introduction into what NIL is and what does it mean for amateur athletes?
Yeah, well, thanks. I really appreciate you having me on the show and looking forward to our conversation. And I won't get into too many of those stories from law school or the overthrown balls out there on the football field. But so NIL is it's a really exciting development in sports, and people feel pretty hot or they feel hot or cold about this issue. Some people don't really care about it. Other people love it. Other people think it's the demise of college athletics. So it's a really, it's a dividing aspect to college sports. It's a new development, and it's changed the game completely. So NIL in general involves the name, image, and likeness of anyone. It's part of the right of publicity, which is essentially the right to make money on your name, image, and likeness. Promotions, autographs. Now student athletes can make appearances and be paid for those appearances. They can do social media promotions. And also, we think about that aspect of NIL a lot as the ability to make money, but it's also the ability to protect your name, image, and likeness. So it's a corollary right there it's also important when you see other people using your name, image, and likeness and not in a way that you don't like or in a way that's not profitable.
Yeah. Well, how did you first get involved in the NIL space and give us a little bit about what your current involvement is, what you actually do?
Yeah, so probably about a year and a half ago now, my law partner, Christine Caldwell, and I, we have some relationships with several compliance departments here in the state of Louisiana. And we were having some conversations with those compliance departments just to kind of find out, what type of issues are they dealing with? What type of legal issues do they arise? And maybe, what's something that maybe we could do in the sports law practice at Breazeale, Sachse, Wilson? What's something that maybe they need help on? And it quickly became clear that they were struggling and wrestling even a year and a half ago with this idea of name, image, and likeness coming into play. Traditionally, the NCAA has not allowed any student athlete to make a penny on their name, image, and likeness. And so, compliance departments were really concerned about that. And so we started to look into it. The NCAA was having some very preliminary conversations and seemed to be making the move towards supporting that. That was really kind of the start of it. And I can remember hearing, it's like, this is a big deal if this happens. I mean, this is a game changer because traditionally, again, compliance departments across the country are reporting violations when a golf student athlete gets an extra club sandwich at the clubhouse after playing golf. That technically could be a violation of NCAA the rules. And so, certainly showing up at a car dealership for autographs and getting paid for that would have been a violation. So we recognized early on that this had a lot of potential to be a game changer, and also there's a lot of different levels and different complexities that would be involved with implementation of how this would go. So currently, our role, what we started to do was just to monitor it, and we were reading everything we could. We still have the Google alerts set for anything that mentions NIL. Early on, it was not a lot of hits that we would get, and then today it's almost overwhelming how many hits we get. So, but it really, we started to look at the different legislatures and their different respective acts that they were passing to allow their student athletes, and that's really what kind of really pushed this NIL into play, was the legislatures taking action and authorizing their student athletes to make money on their name, image, and likeness. And at the time before, so July 1st, we'll talk about that date a lot, I'm sure. Yeah. But July 1st was kind of the D-Day. I mean, that was the day for NIL, July 1st, 2021. And
that's what I wanted to talk about. What, I think you mentioned, hey, look, this didn't happen overnight, although the general public is sitting there thinking, like, NIL, they just woke up one morning. It's like, hey, this can happen, and deals were getting done. Like, what's the backstory? What's the history on that? What's the case history? I mean, you said you've been working on this and thinking about this for years. Like, how did this all come about?
Yeah, so it's not a new concept at all. I mean, you can think about professional athletes. They deal with these endorsements and these rights all the time. So it really has just been foreign to the collegiate landscape. And so, but there's been a lot of discussions about it. There's been a lot of there's the long-standing conversation is should players be paid to play, and that's been a heated debate for the last probably 30 years, and it's still an issue today. So it really came about it started with California. California passed the ironically named Pay to Play Act, but when they did that, they pushed off the effective date until 2023. But that was the first state that had a law that was passed that allowed student athletes to make money on their name, image, and likeness, which was very important. But it really didn't have much teeth on it because it wasn't going to go into effect until 2023. Florida became the second state to pass NIL legislation, and that is what set the July 1st, 2021 deadline. That was the date that law went into effect. And so, really what we had, and then, of course, after Florida did, then the rest of the states, half the states started to see that Florida was doing this. It became this idea that if our state doesn't have one, then that's maybe we're at a recruiting disadvantage. And so you saw a lot of the states in the SEC and in the South, and they all suddenly started to lobby their legislators in getting an NIL statute. So it really went California, Florida, but Florida's the one that really forced a lot of the other states into action, including Louisiana, and most states had a July 1st, 2021 effective date. So that was that's kind of the background into how we got into the space of this July 1st, 2021 deadline. But it's important. It's important to because we were involved with this well before that date. And a lot of people. It's funny. We talk to people about this all the time, and they still don't know what NIL is. It's sometimes it's just not on everyone's radar. If you follow college sports, you know what NIL is. We gave a talk at the Rotary Club here in Baton Rouge, and I would say 90% of the room had no idea what NIL was, and that was in September of this year. So, it seems, for us being involved, we've thought about it and talked about it and watched it kind of develop for quite a while. But we have to remind ourselves that a lot of people don't even, they don't know kind of what that involves. But it's important to kind of talk through what we were looking at before July 1st. We were looking at a situation where state legislatures were passing laws that directly contradicted NCAA rules. So state laws were, that were start to become effective in July 1st, said that a student athlete, had a legal right to make money on their name, image, and likeness, while the NCAA rules said it would, for the student athlete to do that, it would, they'd be deemed ineligible. And so this was I think a lot of times we gloss over that fact, but beforehand we were anticipating a lot of lawsuits. There was discussion about the NCAA potentially filing injunctions across the country to try to stop these laws from going into effect, and tried to argue that the NCAA had the ability to prohibit this. And so, we were monitoring that and gearing up almost for a more of a legal challenge there. And ultimately, what happened on the eve of July 1st, it was June 30th, the NCAA waived. They issued a blanket waiver of their prohibition against student athletes making money on their name, image, and likeness. And so, really what that did to set the stage for kind of where we are and where we've been the last 6 months, the NCAA said if you are in a state that has an NIL law that's in effect, you need to follow that law, and you need to follow your institution's name, image, and likeness policies. If you are a student athlete that's going to school in a state that does not have an NIL statute, you need to follow your institution's NIL policies. So in one sweep of the pen there, they allowed all student athletes, and for the most part, all student athletes. There's some issues we don't need to get into with the international students, but for the most part, they allowed them to do that. But it created a situation where we have 20 so states with slightly different NIL statutes and guidelines. Institutions have different policies, and then you have schools and states that don't have to follow any state law, that are free to develop whatever policy they want. So we don't really have a lot of consistency there, which can be problematic. I know that's just a dump of words and a lot of background, but try to just condense it down. It's a complicated process.
Right, I think it's helpful. And you touched on a couple of things there, talking about there was different timing mechanisms, different states, different schools have different rules. Like if I'm an athlete, if I'm a parent of an athlete, if I'm an agent, if I'm anybody involved in this, like, what should I do to get guidance on this? Where should I go first? I mean, does it matter? I mean, if I'm a high school athlete in Texas, but I'm signed to go to LSU, like what do I do there? Where do I seek guidance? Is there difference? You mentioned there is differences, but like, what are some of those differences, and how should I handle that?
Yeah, so the first place you want to look is the state law of the school that you were going to attend. That's the first place you want to look. Yeah. So if you're a student athlete in Louisiana, you're going to want to look to Louisiana law. First question you need to ask is, does Louisiana even have a statute on NIL?
You're saying this is if I'm an amateur, if I'm a high school guy living in Louisiana, step one would be go to Louisiana statute, and from there. Yes,
that would be the first step. Now, we'll get into that. High school is a whole different animal because most of the state statutes don't even deal with high school athletes. Now, Texas is one of those that specifically prohibited high school athletes from engaging in NIL activities and making money on it, which is why you had a very highly recruited quarterback forego his senior year to go to a state and enroll early into a university for a 7-figure NIL deal.
Yeah.
But so it really kind of complicates it when we talk about if you're in high school. But so why don't we take it first with if you're a college athlete? Yeah. So the first question you want to ask is you want to know is does our state have a law on that? The second question is you're going to want to get a copy of your institution's NIL policy. Now,
where do you get a copy of that at?
Just compliance? Yeah, so the compliance department should be they should be educating all the student athletes on what is permissible in their state and under their institution. But the first, if you are enrolled in school or you have a child that's a student athlete in college, you can feel free to contact the compliance department to say what guidance, can you please let us know what we can or can't do. Yeah. So those are kind of the two main places you need to go and you need to look. the NCAA has really taken a hands-off approach. They have really punted on enforcement of this. They have left it up to the states and to the institutions to monitor and to set the guardrails as to what is permissible and what is not. And I'll give you an example. So under Louisiana law, student athletes cannot promote any casinos or gaming or any alcoholic beverages or there's several kind of 5 things. Tobacco is another one. A lot of states have those same prohibitions, but Florida does not. So Florida, if you're a student athlete in Florida, you can do a deal promoting a beer company. That is not that's not necessarily prohibited in Texas. In Florida. In Texas, their state statutes prohibit student athletes from any NIL deal involving the adult film industry. Louisiana doesn't. So there's all kind of little things here and there that it really just depends on what the state law says of where you are. And then, of course, the policies of the institutions are also equally as important to look at. If you want to kind of take a step back and now look at the high school.
Well, while we're on the college side, one of the things I was thinking about is you said we've got both institution and state rules that we're kind of looking at, and that's our guidance. Is there any guidance from the conferences? Like, if I'm I just use LSU because we're here. We went to law school there. If I'm an LSU student athlete or prospective student athlete, does the SEC come into play ever, or is it just strictly your university policy and the state that it's located in?
Yeah, so it's the conferences have the ability to also to have rules and regulations on that as well. We haven't
done it yet, or no?
Well, we haven't dealt with a lot. We haven't seen that a lot. I think that's where it's going. I do think that the conferences will, at the point where they feel like they really need to step in. But there's concerns. There's concerns for the SEC to just jump in and regulate, because, again, student athletes in Louisiana and other states now have a legal right to make money on their name, image, and likeness, and to restrict that right unreasonably will invite legal challenges.
So it'll be the same thing over again. They've been challenging the NCAA for all these years, and now if the conferences step in, it's going to be basically taking the place, and they're going to go after those conferences and sue them, and the same process probably happens all over again, is what you're saying.
That's right. It could if whatever rule or regulation they put into place really affects student athletes' ability to reasonably profit on their name, image, and likeness.
Yeah. Huh. That's interesting. Now back to the high school student athletes. How does that differ from the college, and then how does that differ? I know you said we talked about the quarterback that went to Ohio State from Texas, the reason why he did it. What's different with the high school amateur athlete that we need to be aware of?
So the primary difference is you also bring in a third component, which is the high school athletic associations. So the steps that you would look at, we'll take Louisiana just because I know Louisiana law very well. So if I'm a high school student athlete, and I would first look to the state statute, and I would ask, does our state statute even address it? Does it give me or prohibit me from making money on my name, image, likeness? The answer is no. The state statute doesn't address any athletes aside from collegiate athletes. The next step you would look to would be you would then go to the LHSAA. They have rules that prohibit, and really that they try to promote amateurism in the same way that the NCAA has. And most high school athletic associations do not have a rule that is very clear on this issue. And the reason for that is because it could affect college recruiting. So if you were a high school athlete and you were signing autographs or making appearances in exchange for cars, that would have likely affect your eligibility to play at the next level. So there wasn't really as much of a need to enforce that at the high school level because the institution took such a strong stance against that and the fact that it could affect your future eligibility to play college sports. So the LHSAA and most of the high school athletic associations, their rules are unclear, but they have taken the position that for a high school athlete to engage in NIL will render them ineligible. So
ineligible just for high school athletics?
Just for high school. So okay. It will not affect that the high school athletic associations don't have any ability to tell the NCAA to affect the eligibility there. But they have said that your high school eligibility will be jeopardized if you engage in NIL activities. Now, Louisiana, that is something that we think is ripe for legal challenges because the rules are unclear. There's several high school athletics associations in the country that allow it, California being one. I think New York just recently changed, and you're seeing some high school athletic associations change their mentality on this. And I think that is a change that we likely see more of as the NCAA's the right that they granted is being codified, and it's not going anywhere. I've imagined we would see high school athletes being able to utilize that with a little bit more clear direction, but it gets real muddy in high school because the rules of the high school athletic associations are less than crystal clear on whether you can or you can't. So we deal with high school administrators a lot. Just what do we tell parents? And ultimately, what you are risking here is the eligibility of the student athlete. And so it's one of those things. If you don't have, if you tell your student athlete that you can't engage and you report to the LHSAA, they will likely at this stage tell you that you are ineligible to continue playing any other sport.
So it would be all sports. It's not just one particular. It's like I'm a football player. I do something football related. I can't play baseball. I can't play basketball. Also.
No, you've lost your amateur status.
What about as far as we talk about? There's different state laws, different laws for high school players, and we're looking at what the state high school association is kicking out, and then the institution and the state. What if I do something in high school that's completely legal where I live as a high school athlete, and I'm signed to go play in another state, and what I did in high school would not be fair game, I wouldn't be allowed to do that if I was attending a university and they had a rule in place. Does that affect my eligibility in any way at that university, or do they just say, hey, that happened in high school, we're now moving on to this other phase in this other state. What happens from this point on is all that we care about. Like, what's the thought process there?
It should not affect. It should not affect that at all. Your eligibility at the college level. So, during the recruiting process, if you're getting recruited by a lot of different states, that doesn't need to be one of your considerations. Is do they allow it or do they not at all? Now, the NCAA, if they came back eventually and changed that. Or kind of restricted those rights to do that, then they would be the ones that have the power to say you are ineligible because of your high school activities to play anywhere. But we're not seeing any of that at all.
And they're probably not going to go retroactive on us either and be like, it's probably going to be like from this point forward, this is going to happen. We're not going to penalize anybody in the past, correct?
Right. So if University of Texas is recruiting, somebody in California, which that it does happen. They get a lot of good recruits out there. The California High School Athletic Association allows student athletes to engage in NIL activities, and Texas does not allow their high school athletes to do that. There's no problem with that at all. There is no violation, and it's two separate things. And think about it. These states and the institutions in these states, even if they don't have a law allowing it, they don't want to restrict their ability to recruit in states that allow it, for high school athletes. But you're seeing the transfer portal, that's where it gets, really, really, really complicated, because if you have a deal in place in one state, that doesn't mean that deal can continue in another state because the laws are different.
I was thinking about that as far as somebody from Florida that has even a high school or a college player that has something with an alcohol. You said alcohol is allowed in the state of Florida, and then they come to Louisiana, then it's not allowed. They won't be penalized, or will they just stop the activity? What's the thought process there?
Well, the question is going to be, it's going to be a conflict. Yeah, well, it's an interesting one. I mean, I think they would not be able to continue doing that in Louisiana, but the question is going to be, where is this activity taking place? The brewing company in Florida may still want this student athlete to show up and promote their Florida beer. So I think that would be problematic when you come into a state that specifically prohibits it. But this is, what's really interesting about this, and for the first time that we're seeing, this is an issue of state laws and the conflict of laws. We're not really talking about the NCAA here, and that's been a concern for student athletes in college and the compliance departments for the last 50 years. Is we want to stay out of the hammer of the NCAA coming in and saying that you violated one of our rules. Now we're talking about different state laws, different institutions' policies. And all of that can change things.
Yeah, that's interesting. What are you seeing? I know we're starting to see the headlines around National Signing Day about boosters, and you're seeing this NIL, I don't want to call it a slush fund, but this NIL fund that the University of Texas is creating. Boosters are getting involved to raise NIL funds. Transfer portals heating up. There was an attorney, I think, offering people in Virginia, if they went to UVA to do XYZ automatic, you come here, you get $15,000 if you promote my firm. What are your thoughts on that? What do you see the issues? I mean, what do you think happens there? Or is there any big issue you see coming out of this, or how do you handle this?
Yeah, so, this is the closest that we've got, that we've seen where we are getting really close to violations of current NCAA rules. So when the NCAA, when they waived their rule prohibiting NIL, they made it very clear that their rules prohibiting impermissible benefits or recruiting inducements, that is pay to play, that is all still prohibited by the NCAA, and they will still enforce those.
So they'll cross over and say, hey, this is pay to play, this isn't NIL, and the NCAA will step in at that point.
Yeah, so I'll give you an example. If you have, if you're a student athlete and you have a potential deal for $100,000 to do an autograph signing, if you don't go to that autograph signing, but you get the $100,000, then you haven't. There has been no exchange there, and so that is a impermissible benefit that you receive. So there has to always be an activity or an endorsement or an appearance or something tied to the exchange of compensation. If there's not, and money just gets transferred into account of a student athlete, that is still a violation of it's been a violation, and it still is. And it will probably always be if the NCAA is allowed to continue, making rules on that front. So, you see these collectives, as they're kind of being called, and they pop up, and this, it's been really interesting because this is the first signing day that we're seeing, with the NIL in place. But that's really when we saw a lot of states and a lot of these different groups coming together and making collectives in their state. And Texas is a great example, and they have two. They've got one $10 million fund, and they've put together a board of directors of notable alumni of the University of Texas that will decide, which athletes will support which businesses down the road. But what's concerning to me is what you're hearing is there is nothing about how these funds necessarily are going to be used. There's nothing about a promotion of a business or a promotion. It's getting very, very close to a recruiting inducement. It's a signal to say that our school has an alumni base that has $10 million ready to spend on its athletes. And Texas even got even closer to that when they said $50,000 per offensive lineman. Now what they're not saying is that we've seen the deals with the offensive linemen with barbecue restaurants in Texas and Arkansas. That's on brand, that makes sense, but it's also within the initial kind of scope of what NIL is intended to be. There's no reason, and I agree that student athletes, because they're student athletes, shouldn't be prohibited from promoting or using their popularity. And most of these deals are not massive deals. I mean, there's $500 to show up at a holiday Christmas party can be a pretty big return on the investment. When you have when you have somebody, if you think Joe Burrow here parking cars at a Christmas party or being a valet wouldn't be a pretty big hit. Now he could do that.
Yeah.
And so but these collectives, the narratives surrounding the collectives are problematic, I think. The offers to just pay money. I mean, that is pay to play.
You said like, hey, look, this is if you're an offensive lineman, this is for you, versus like, hey, there's a nexus between your personality, your popularity, our brand, and then we're going to discuss. Then we're going to decide how we pay you. So yeah, it does sound like, hey, this is for you if you come here, not this is for you because of who you are and how you can help our brand. And then when you describe collective, what is a collective? I don't. Can you help kind of unpack what that is?
Yeah, so it means people use that in different ways, but the way that I think about it, it's a collective of people coming together to invest funds towards a goal of supporting the NIL and creating NIL opportunities for student athletes. So that's you hear it used sometimes meaning to pay a whole team or to do all of that, but really I think of it as a group of individuals coming together to support opportunities and NIL opportunities. The idea alone is not it's not as concerning to me that people would want to do that, except it's the rhetoric around it, and it's also they're not talking about their current offensive linemen. They can go do deals with the current offensive linemen. They are using the publicity of that to signal at a good time, we need some top offensive linemen who wants $50,000. Now, and again, there's a lot of problems. I think that we're starting to see, I think what a lot of people expected to see maybe earlier. It's some of the worst of A, not knowing the rule, but B, not really being concerned about anyone enforcing it because of how murky everything is. And the NCAA's saying that, look, we're not in the business of interpreting everyone's NIL. The 28 different states that have NIL laws, we're not going to interpret your institution's NIL policies because we've got a lot of institutions. So that's up to y'all. And that's kind of, I think, allowed people to say, who's gonna stop us from doing that? And that's a problem. We saw one 2 days ago with I think it was it Eastern Michigan, Central Michigan, but there was a tweet that was put out towards the transfer, the quarterback at Oklahoma that's in the transfer portal that says, "Have you considered our college? We have $1 million ready for you to play for 1 year." I mean, that has been a violation of the NCAA rules in the past, and it is today. And I do think this is a place where you might see the NCAA reinsert itself into showing these really egregious examples of this has nothing to do with NIL. NIL wasn't mentioned in that tweet at all. That's a pay to play and an illegal recruiting inducement.
I mean, these are the things that you and I had to deal with. I mean, being the top caliber athletes we were.
Of course.
I mean, I was just turning down deals left and right. Just people were like, hey, here's some money. We want you to come be hurt at Northwestern State, and for you at LSU.
It was really exhausting. It was just exhausting to just turn.
There's a lot to work through.
Turn away all that money. Oh, yeah, that was a real difficult time there.
I hear you. Well, good. Well, I know we've talked about a lot of things, and I think the most important thing, I mean, it's a lot to understand and to break down for somebody that's new to this, and a lot of student athletes, parents, coaches, even compliance departments. I think we're seeing that there's differences in the ability of compliance departments to analyze rules or help their student athletes. But I think the good framework and good starting point for everybody is step one, go look at the state legislation, what it says. And then two, if you're a high school athlete, LHSA, if you're in Louisiana or whatever your state athletic association, if you're at a university, just go to your compliance department and start there. Do you have any parting shots, any last like big things that you want to talk about, or that you say, hey, look, if I'm a prospective student athlete, if I'm a family, if I'm even an agent or a compliance department, anybody that might be listening to this, is there anything you want to kind of say, hey, look, this is something that you should think about that we haven't touched on yet?
Yeah, I think it's important. A lot of times you hear the negative about NIL. There's a lot of positives to this. There really is, and I think it's remembering that these student athletes. Most of them are not getting $50,000 deals to do very little or to do autograph signings, but they do have large social media followings because they're they're in the public more. I mean, especially at the larger institutions. So there's a lot of smaller deals that are awesome that we're seeing. To promote local stores in Baton Rouge, or a boutique. You get a soccer player that's in a sorority that promotes a local boutique by with some new jackets or game day wear. That stuff's very successful for the brand itself, and it's not game changing for that student athlete. It's not like they can now just retire on the $500 they made from the promotion. But at the same time, they are not deemed ineligible and put into the headlines and now can't participate in their sport for doing that deal. So I think it's important that everyone remembers the scope of kind of what we're talking about. There's always going to be individuals and boosters that want to push this thing and get the biggest advantage. And that's something that it's going to have to be dealt with. But I think overall we've made a right step into removing that barrier, because again, remember that all the student athletes, their classmates and at the university who weren't student athletes, they all could do that. They all could do the same things without potentially having any problems or being removed from their sport or a hobby of theirs. So this has really equalized that, but there needs to be some stronger guardrails put up. There needs to be consistency across the board. And I think that what we're looking at is potential federal legislation. This will come back towards the middle right now. I think the NCAA is going to step in here shortly and start enforcing their current rules. But I do think it's important for people to remember that there's a lot of student athletes on the Division II and Division III level too that are now able to do things that other kids hold camps. When we were playing, we couldn't train athletes or hold a camp and get paid for that. Now they can. And so
we're actually going to utilize that with, our daughter and some of her teammates. We're going to get some athletes just because it's something like, I'm not an expert, but you've got a college athlete that has a little time and needs the money. And it's like, they're not getting rich, but I remember being a student athlete and a couple $100 went a long way.
Absolutely.
Talking about rent, talking about groceries. We didn't have everything we needed, and it just kind of helped out. And I think you're right. That is a positive, and that's what a lot of people should be looking at this as.
Yeah. So, but there's a million different legal issues. Yeah. There's and again, the other thing I would be good to point out is that if you're a student athlete, just because you see a deal that's done and the way that deal is done in Texas, that doesn't mean that deal can be done here legally. So
yeah,
there's some schools are allowed to facilitate arrangements and deals for their student athletes, and other states prohibit it, like Louisiana. The LSU athletic department cannot arrange a deal between a brand and one of their student athletes. A coach can't do that under Louisiana law. Really? Other states that don't have that, they don't have a state law that prohibits that, and the institutions in those states have said, well, we should be able to arrange those deals. So, so that's a good example of how different the different states and where we are with the guidelines. So when you read that BYU has arranged a deal with the entire football team, or given all the walk-ons scholarships, through a brand that's come in to pay, to promote this deal, that can't happen in Louisiana. And so it's just important to remember that we're kind of dealing with a lot of different interpretations and different laws and regulations on this. And so, stay within your bounds. If you're a college athlete, the compliance department, they're up to speed on this, and they have to be.
Yeah. No, and I think, the biggest thing about this, we talk about this in class, is it's an evolution. It's constantly changing. States might have a law in the books right now, or schools might have a policy in place, but they're going to go back and revise and look and make adjustments as they see fit. So I think it's smart not just to be complacent. Like something happens, continue to go back to those resources before you do your next deal. Continue to use your compliance department. Continue to check on the state legislation. So with that being said, Dave, man, I really appreciate this. This has been fun. I think just for me and you to get together and cut it up in person, or I guess in person, but to talk about something that we talked a lot about this past fall. But I think that there's just not a lot of information out there about this. And I think that being able to give this insight is extremely important to everybody involved in the sports, whether it's, like we said, whether it's the athlete, family compliance department. And what our listeners, what I'd tell you to do is we're going to have some show notes that are attached to the bottom of this podcast, and it's going to have our contact information in it. If you have any questions, please feel free to reach out to David or I, and we will try to help out in any way we can, help direct you. Obviously if it's a Texas issue and we're Louisiana attorneys, we might not be able to work on it directly, but we can point you in the right direction or help you find somebody that might be able to help you out. But so go take a look at those show notes. If you have any questions, or if there's something you'd like us to discuss on a future podcast, please let us know, and we'd love to touch base on it. So, David, thank you once again. This was great. And also thanks once again for the sports law fun, and look forward to doing that again next year.
The information in this podcast is educational and general in nature and does not take into consideration the listener's personal circumstances. Therefore, it is not intended to be a substitute for specific, individualized financial, legal, or tax advice. To determine which strategies or investments may be suitable for you, consult the appropriate qualified professional prior to making a final decision.